The next case to come before the court is Louis Askew v. Joseph M. Brafchak. Are the parties here? Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes, and if you do for rebuttal, and if you do plan to reserve time, please let me know as I'll be keeping track of the time. Arguments are being recorded. Please keep your voices up, introduce yourselves at the podium, remain behind the podium. You shouldn't use the names of children or minors or victims during your argument, should that be relevant to what you have to say. And you can refer to them by initials or generic terms in those instances. The judges have read your briefs and we're ready to proceed when you are. And I would just ask the appellant, would you like to reserve time for rebuttal?
Yes, Your Honor, if I could have 3 minutes for rebuttal, I believe that would be sufficient.
Okay, and I will just say, I don't like to interrupt when you're in midstream or someone's going back and forth, so I'll do my best to let you know, but you may start to cut into it before I alert you.
Thank you.
Sure.
May it please the court, my name is Paul Neuendorf and I represent the appellant Louis Askew. And as I indicated, I'd like to reserve 3 minutes of my time for rebuttal. Mr. Askew suffered serious injuries when his car was struck by a truck owned by Summit County and operated by a county employee. Mr. Askew comes before you today because the trial court erroneously dismissed his claim, leaving him with no opportunity to prove his claim against Summit County and with no recovery for his serious bodily injuries. The trial court's dismissal here was purely procedural in nature. In a previous action between the parties, liability was admitted. The merits of Mr. Askew's claim formed no part of the trial court's decision. The entire basis of the argument here, the reason that we're in front of you, is simply a matter of whether we are going to exalt form over substance. The entire basis of their argument is premised upon the idea that the original action between the parties, which was filed by Mr. Askew's passenger, James Smith, against Askew in the county, was never properly commenced against Summit County. The county then proceeds on to argue that if the original action is never properly commenced against the county, then Mr. Askew's refiling of his claim following a voluntary dismissal cannot relate back to the original action under Ohio's savings statute. That his refiling is therefore a nullity, and the trial court accepted that argument and dismissed the action. Both the county and the trial court were wrong. The argument made is that the original claim was filed against...
The original action was filed against Summit County Fiscal Office.
I disagree.
And what if we allow, what if any office with the title Summit County could be substituted for Summit County? What if someone sued the Summit County Child Enforcement Agency?
The allegations that a person makes, a cause of action, is stated in the body of the complaint. We are talking here about a misnomer that is confined to the caption. This has been true throughout the pleadings in the original claim, as well as when Mr. Askew refiled this claim. He refiled it, it says Summit County Fiscal Office in the caption, but the body of the complaint talks about allegations against defendant, quote, I hate to use air quotes because I hate that, defendant Summit County, close quote.
So you're saying the caption just says Summit County Fiscal Office as the party, but the actual body of the complaint alleges that it's Summit County that you're suing?
Exactly, exactly. And that was true in the original complaint filed by the passenger Smith, as well as in the refiled action throughout all of the pleadings in this matter. The causes of action, both the passenger's cause of action, Mr. Smith, as well as Mr. Askew's, it's been against defendant Summit County as stated in the complaint. So if the fiscal office is going to be denominated as the defendant despite the fact that there are no allegations whatsoever in any of the pleadings claiming that the fiscal office did anything wrong to anybody here, we are elevating the caption over the substance, we are elevating form over the substance.
Doesn't the caption have to be right, because that's the named party, and then that would dictate who gets served?
I think that, as we've outlined in our brief, the civil rules cover that circumstance. The whole purpose of the civil rules, as stated at the outset, is that cases should ideally be decided upon their merits and not upon procedural niceties. Rule 15C, governing amendments to the pleadings, covers this very situation where somebody is misnamed in the complaint. Clearly, those pleadings can be amended to properly name the party, which was done here, and the court granted the motion for leave to amend. The amended complaint was filed, deemed filed by the court's order, and served upon Summit County. The idea that somehow the fiscal office was ever the party here is simply false. The county has been the party throughout. The first action was properly commenced against the county. They defended themselves throughout the matter, and after the statute had ran and there was refiling, now they come in and say, oh, well, that action was never properly commenced, and therefore you can't relate back under the savings statute with your refiling. Point out that the court's order here, which dismissed this action, is essentially finding that this fiscal office was the actual party sued. That's not what the complaint says. That's what the caption says. And that's, for that error, we go down the Mary Garden path here, as all of the pleadings after that, nobody changed the caption, essentially.
Counsel, in regard to this, I know I think you filed leave to bring in the original complaint and so forth.
Yes, because the trial court referred to those documents in its order.
Right, but the original complaint was not submitted to the trial court as an exhibit?
I don't believe it was, Your Honor. I don't believe it was. But
Did anybody contest what was in the original complaint?
I'm not sure I know what you mean by contested.
Well, did they in filing this motion to dismiss and arguing statute of limitations, did they say that the Summit County Fiscal Office was not named in the caption of the prior suit?
No, they said, and it clearly was. I mean, again, the caption in all of the pleadings have always said fiscal office up until the point where we amended it and clarified that it was the county that was the party. And again, this is where this kind of whole thing started. Now, in the defendant's brief, they cite a whole series of cases that they claim support this idea that county department, or police department, for example, in the case of Richardson, that's cited there, an 8th District case. There's also a case against the city of Cuyahoga Falls City Council versus Robards, where the allegation is that the council had acted improperly. And I was cited to another case involving utility in the city of Canton. All of those cases have something in common. The parties in those cases meant to sue the defendants that they actually sued. The claim in Richardson was it was a high-speed motor chase with the police, and the allegation was, police department improperly engaged in this chase and injured people. I don't know the fatality, actually. But the claim in the complaint and in the caption was against the police department court rules. The police department is not a suable entity. You have to sue the city. Same thing with Cuyahoga Falls versus Robards. Can't sue the city council, got to sue the city. But the dispute in that case was a dispute against the council. They were alleging the council had done something improper. Same with that Larson versus City of Canton utilities claim. Claim against the utility. Nobody has ever claimed here that the fiscal office did anything. And certainly, I see Summit County motor vehicles all over the streets of Summit County. I don't think I've ever seen a vehicle that was from the fiscal office. I don't know whether they have vehicles or not, but clearly the vehicle here was not a vehicle operated by the fiscal office. And there was never any claim that the fiscal office was involved here. Again, this is simply in the caption. And so if, and by the way, even though we do not have the pleadings from the original action. I did file a motion that they be included, because I believe it was important that they be included, so that this court could refer to them. That motion was denied. But in any event, you don't really need to look back any further than the refiled complaint here to see that fiscal office is in the caption. A body of the allegations in the complaint are against the Summit County as defendant, as that specifically says, defendant Summit County. So there's no confusion here. The county has not been prejudiced, and the case law that we cite to indicates that that is a factor. If you're coming to relate things back, look at, is this defendant going to be prejudiced now at this point in time if we allow this to relate back? Counties defended themselves against the original case, they defended themselves in this case. There's never been any question what the claim was all about here. And all we're fighting over, what they're fighting over, is what was in the caption. You might reasonably ask why that got in the caption in the first place. Well, again, Mr. Askew didn't file the suit originally. It was suit filed against him, and he had to make a cross-claim for his own injuries. I can't read the mind of the counsel for Mr. Smith, but I did know, I thought it was interesting, that after we amended, and the court granted our leave to amend, we filed a request for service with the Summit County Clerk of Courts, requesting service upon, air quotes again, defendant Summit County. Where did the Clerk of Courts send that summons? To the fiscal office, who signed for it and accepted it. Looks like fiscal office is where service is made, from what I can tell from looking at the dockets and the pleadings in this matter. This is a matter that is governed by the civil rules. The civil rules provide that these matters are to be determined on the merits. It doesn't mean that procedure doesn't matter. Procedure does matter. But here, we're dealing with a misnomer. You want to look at the case that's most analogous to this case. That would be Milos versus Doe, cited in our brief. That was a case where the court allowed an amendment to change the name of a party. It was a dispute between whether it was Nationwide Insurance Company versus Nationwide Mutual Insurance Company. Statute had run in the meantime. They allowed the relation back, noting that there was never any question who the actual party was here. The complaint attached the insurance policy of the proper insurance company. The allegations were against the proper company. It was simply designated, misdesignated in the caption. I urge you to look closely at the Milos case. I believe that is highly supports the position that we have here, as well as the rules, Rule 15 and Rule 3, and the interplay between commencing an action or attempting to commence an action. Essentially here they're saying there was an attempt, but you didn't commence it. Rule 3 governs that attempt to commence, and Rule 15C allows relation back of an amendment in these circumstances. And the saving statute governs Mr. Askew's refiling of his complaint following his Rule 41A dismissal. So, if this court were to uphold the trial court's dismissal, we're elevating the caption over the substance of the complaint, and in the refiled action, as well as all the pleadings in the original action, we're elevating form over substance. We urge you to reverse the trial court's determination, send the matter back, and allow for a determination on Mr. Askew's claim on its merits. Thank you.
Thank you, and you will have your full 3 minutes for rebuttal.
Good morning, Your Office. May it please the court, my name is Jillian Deinhardt, here to represent on behalf of Summit County. I note that the appellant's argument is talking about form over substance, but the Ohio Supreme Court in 2008 in Leneve versus Atlas Recycling, which talked about the John Doe rule in Civil Rule 15. I quote them and I say, "The civil rules are not just a technicality, and we may not ignore the plain language of a rule in order to assist a party who has failed to comply with the rule's specific requirements." While this case pertains to more than just one civil rule, this is almost a first-year civil procedure exam, we're talking about layers of rules here, but the point is the same. While appellant discusses that the caption is different from the body of the complaint, it's not true. Summit County is used as a shortened term for the full plaintiff. Plaintiff all along until December 5th of 2022 was Summit County Fiscal Office.
And And when was the first objection? Now, this goes, I know a little bit to the complaint, so I'm not sure exactly what's in the record or what's not without pulling it apart myself. But the trial court did refer to the original complaint. And it doesn't seem as if there is an objection that the original complaint did in fact name the Summit County Fiscal Office in the caption of the case.
There is a defense was raised in response to the cross-claim that Mr. Askew brought from the first claim, and that was brought on September 4th of 2020.
But was that with the new suit or while the old suit was pending?
The old suit. That was with the old suit. And to the extent that appellant has said, well, it doesn't make sense that this case is against Summit County Fiscal Office. Nobody understood this case to be Summit County Fiscal Office. Well, to the extent that he attempts to use that against Summit County, it's also true for plaintiff in this case and the original case. Every time this case was touched, and we did defend this with the affirmative defense having been raised, it should have raised some alarm bells. This is not the appropriate party to be sued. To the extent that this is just a caption issue, the caption does name the parties. It is what the summons sends out upon. It is.
But the problem is, or at least their argument, the problem is that it all went to the same entity anyway. Because the Summit County Fiscal Office is who pays the bills. Now, I understand, I used to be a prosecutor in the civil division, so I represented all of those people. That's the first thing you raise is that it's not a proper party class capacity. But nonetheless, in these circumstances here, the Summit County Fiscal Office did in fact receive service both times. And Summit County was put on notice of it and defended this suit.
Yes, Your Honor, we did. And in defending, we raised the red flag. We jumped up and down and said, you're suing the wrong party. This is a capacity issue. It is not a misnomer issue.
Did you file a motion to dismiss with the original?
No, we did not, because the Civil Rule 3 period had not yet expired. And had we filed a motion to dismiss, they would have just amended the complaint and essentially our defense would have disappeared. But that is exactly how Mr. Askew or...
Oh, your defense would, I'm sorry, I'm interrupting you on that. I apologize.
No.
Your defense, we're both anxious because we don't have much time. The defense would disappear in regard to the statute of limitations, but it wouldn't have disappeared in regard to the capacity issue.
Well, had the plaintiff, or at that point, the cross-claim defendant, amended their suit between the, may have been after the statute of limitations had expired, but it would have been before the Civil Rule 3 time expired, it would have applied. 15C would have applied to this case, but that's the key to this entire argument, is they didn't amend below. That's why the saving statute doesn't apply. It's why this case cannot relate back to the original filing, because there was never a case against Summit County in the original suit. And to the extent that we defended, we were there, essentially you're saying it wasn't prejudicial. I don't disagree, but prejudice goes to those misnomer cases. It doesn't go to the capacity cases. A suit against a person or an entity that doesn't have capacity can never be commenced. That was a recent court decision on the 2nd District in Millette versus Portsmouth City Council. It's also in the 1992 decision from the Ohio Supreme Court in Patterson versus Vietnam Auto Body.
So let me ask you this. Because when you're on the court, because you always have to think of the ramifications of the decisions, not just the specific fact pattern it's provided. Let's say the county had done a global settlement with everybody, okay, for whatever reason. I know that probably it's not the way it should have been, but, maybe, who knows? But had done a global settlement, and a separate suit not needed to be filed, okay? Are you saying because this cross-claim didn't name Summit County in the caption, that could have all been overturned?
No, Your
Because
Honor.
it's void?
I'm sorry.
No, because it's void?
No, Your Honor, because that's a settlement. You can just as easily settle before suit as you can while you're in suit. So the settlement is all the parties come together and say, I may have had defenses here, I'm walking away from them because we have come to a bargain. And maybe that value would have considered what that bargain was, because certainly had Summit County decided to settle with Mr. Askew at that time, they would have known that well, we're waiving possibly a defense that we raise in the future to get the entire case dismissed. So that it would come at a bargain. It would not necessarily.
And I understand your argument with someone. Let me make it even more complicated and harder. What if an award had been rendered, if judgment had been rendered, and Summit County had paid? It could overturn it on the basis that it never consented to being sued.
Yes, Your Honor, I believe that it could. There is language, again, in that Patterson versus VM auto body that the case is void because it can never be commenced. And that's really the linchpin between capacity and misnomer. Misnomer doesn't do anything to the legal ability to sue that entity. It is all about just a mistake. The case that appellant relies on, the Milo versus Doe, that case was about a company, it's about Nationwide, not a party that could ever have a claim regarding capacity. And it was Nationwide Mutual versus just Nationwide Auto Insurance. It doesn't have the same interplay here because we're talking about a government entity that by law, everyone is aware of, does not have capacity to be sued. To work a little bit backwards, Your Honor, to your claim about, well, Summit County Fiscal Office pays the bills. We don't know that that's actually who pays the judgment. There's nothing about that in the record. But even if they did, it's still improper. Service under 4.2 is different than who can be named. Who can be named is much more stringent set of standards. 4.2, I want to say it's L, but it could be N, talks about where you can serve a government entity, and there's a whole list of different places that you can serve. But that's service. You could also attempt to sue me, and you could serve it upon my 20-year-old daughter. Doesn't mean she's been sued in this matter. To go to sort of a related argument that appellant has made here is that, well, in the end, after we amended the complaint, it was served on Summit County Fiscal Office, even though we asked that it be served on Summit County. What happened is there was never actually an amended complaint filed. The court granted leave on December 5th, 2022. The amended complaint was attached as an exhibit as it needs to be under the rule. So when Summit County clerk reissued service, they did so on the first complaint, not on the amended complaint, because the amended complaint had never actually been physically filed. The filing fee costs for filing an amended complaint and reissuing summons were never paid. That is why that happened. That is why it was served on Summit County Fiscal Office, not because the clerk's office has some understanding that that's where all service for Summit County should go. In fact, it's probably not even likely. It's probably goes to the law department. I want to touch briefly upon waiver, because I think that's where some of the questions started out here this morning. The second district in Millette held that you cannot waive a capacity claim, because again, it would be a void judgment, it's jurisdictional. Even so, we didn't waive it, we raised it in response to an amended cross-claim. I believe appellant will use in his rebuttal that this wasn't his amended cross-claim, that they only amended part of their answer, but regardless, once they filed that amended cross-claim, we had to respond. We had to file a reply to that, therefore we had to raise those defenses, and like any other amendment, it wipes out the pleading beneath it. Furthermore, as to waiver, we obviously raised it in this suit, in the refiled suit. This was a motion to dismiss argument. We couldn't have waived it in the suit. Appellant made a brief reference to the savings statute. The importance of the savings statute is that you needed to have an underlying case that was commenced or attempted to be commenced. As a refiled action, though that's colloquially what we refer to it, it is actually a brand new action. It is not a reiteration or a filing that is dependent upon the previous complaint. To that end, because Summit County, because a defendant with capacity was never sued originally, the savings statute cannot be used here. With that, though, I think if there's no questions, I think I've covered all of the various topics that need to be raised, and I would rely further upon our appellee brief for additional instruction.
First off, just briefly, I'm not sure what the case law governing whether a judgment can be vacated or not has to do here, because there's never been any judgment against anybody rendered.
No, there has not.
Yeah.
That's why I prefaced it with, we have to look at what our case law, when we interpret something to mean what it may impact on other things.
And
So the point
Mr.
is.
Smith received a
void is
settlement.
void.
I'm sorry.
No, I was gonna say, so the point is, that I think she's making, it would be void and therefore was never waivable.
No, I understand that, and if we were making a claim against the Summit County Fiscal Office, whether in the original action or in the refiled action, I'd agree with it. But again, the claim has always been against Summit County for actions of its employee in the negligence of operating a motor vehicle. The argument's made that somehow there's a difference in their position here, whether the defendant is a municipal or public entity versus a private one. That's how they're trying to distinguish the Milos case here, because that involved a corporate entity. If a corporation sues some corporation that doesn't have a charter, or the charter was revoked, they're just as much of a non-sui juris entity as the Summit County Fiscal Office is. The same would be true of an individual who didn't exist. I mean, if I name a John Smith, and there is such an individual, well, he's a real person that can be sued. But if I name somebody who, by my mistake, by a misnomer, doesn't exist, there is no such person, by her argument, I could never amend to bring that person in under the saving statute once the statute of limitations expired, because regardless of what I alleged in the complaint, the person that I named in the caption didn't exist and was therefore, quote unquote, non-sui juris. The court here really doesn't need to look back at the original pleadings in the original claim, although, as I said, I think would be helpful given that the court did cite to them in its order. The idea that the original action was never commenced against Summit County, again, belies what went on in the pleadings in that case. And I believe, in fact, even though we don't have a record of that case, that this court can take judicial notice, not for the merits, but certainly to see what was filed and what the allegations were. And it's the same for the courts, for the police court as well as for the court of appeal. So here's the situation. Yes, if in fact you read any of the pleadings here as bringing a claim against the Summit County Fiscal Office, yeah, they're right. Fiscal office can't be sued. That's clear from the case law. But the cases that they're talking about, the cases that they're relying on, are cases where the claim was made against that non-sui juris entity. That was never the case here. The claims start all the way through. There's been a claim against Summit County. They can certainly be sued under the municipal statute for the negligence of their employees in operating a motor vehicle. They have certain immunities and other things, there's limitations on damages, but the law, the statute is clear that they can be sued for this type of conduct. The county.
I'm going to have to ask you to wrap up here.
Again, once again, we believe this is a mistake in the caption, a misnomer, and we urge you to reverse the trial court and allow Mr. Askew to remedy for his actions. Thank you.
Thank you. Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of court will mail a copy of the decision to you on the day that it's released, and it will also be posted on the Ohio